This conference will now be recorded.
Hello and welcome everyone. Good afternoon. This is our fourth lecture of contract law. So we will discuss about learning outcome, uh, understand how a contract can be discharged. That's mean that how contracts can comes to an end. So contract is a legally binding promise, writing or oral by one party uh, to fulfill an obligation to another party in return for consideration. A valid contract is one that meets the basic elements of contract law. For example, you sign to buy a blue house, uh, and the house is blue, thus the contract is valid if color is same. So a voidable contract provides the option to uh, rescind by either party at the creation of the contract. It is valid, but it could be voided in the future. So, what are the essential elements of contract? There are four main elements of a valid contract. Are legal requirements of formation of a contract are number one is offer. Number two, legal requirement of formation of a contract is acceptance, and number three, agreement and consideration. So basically, there are four main ways contract terminator can be terminated. There is a difference. So by performance, by agreement, by breach of contract, by the law of frustration. So let's start with the by performance. The contract runs its course and its contract is performed by agreement. Uh, if the parties agree to end the contract by agreement with another contract, breach of contract, the innocent party has a right of termination for breach of contract when party does not deliver what was promised and is in repudiatory breach or another agreed standard of breach. By the law of frustration, the underlying circumstances of contract change, which material alter the performance requirements of the contract. So, first is a by performance. The contract is carried out and completes its terms. By agreement, the parties concur to dissolve the agreement by mutual consent and enter into another contract. Then, by contract of breach, means when a party fails to uphold its end of the bargain and engage in repudiatory conduct or another accepted form of breach, the innocent party may terminate the agreement. And law of frustration, uh, if the contract's fundamentals conditions change, the terms of performance must be also change materially. So, when both parties termination by performance, when both parties to a contract have performed all their obligations under a contract, including all express and implied terms, a contract comes to an end. So each of the parties have performed their obligations with perfect precision, exactly as was specified by the contract. And if the contract is for a fixed term, say 2 years, if the contract has been performed with that perfect precision as at the end of the 2 year. So a contract comes to an end when both parties have fulfilled all of their commitments, including all stated. Additionally, if the contract is for a certain period of time, such a 2 year, it must have been carried out precisely as of the end of that period. So uh, next is a few words about contract performance. Any deviation from the contractual obligation will amount of a breach of contract. In Bolton versus Mahadeva, the contractor was required to install a central heating system. The heating system did not work. Contractor couldn't claim payment. He did not fulfill the primary obligation to heat the house. Basically, the heating was not working. So, because heating system was not working, so contractor could not claim payment. So, in contract for services by a contract, the obligation to performance may not be so strict. The obligation is usually not to achieve a specific result, but just to exercise reasonable care and skill when performance the contractual services. But it depends on the precise terms of the contract, what the contractor is promised to do. Uh, Circumstances of the contract may allow payment for part performance of a contract on a quantum uh, merit basis. A reasonable price is required to be paid for work performance performed at the request of the other party. This enables the performing party, the contractor or supplier, to get paid fair and reasonable remuneration for their work. It requires a contract where the obligation to perform are advisable, such as by phase of milestones. So payment may be recovered for the obligations completed where partial performance has been accepted by the other party prevent complete performance by a party ready, willing, and able to perform, or substantial part of the contract has been completed. Uh, any departure from the contractual requirements shall continue constitute a violation of contract. So, Bolton instructed that the contractor set up a central heating here in case of 1972 case laws. It says the heating system was inoperative, was not working. So, due to its failure to fulfill the principal commitment, the contractor was unable to get payment. So typically, the responsibility is to deliver the contractual service with reasonable care and competence rather than to attain a scheduled goal. And work conducted at the other party request should be compensated at a fair rate. So if needs a contract with breakable performance responsibilities such phase or milestones. And there is a uh, page 6, an IT consultant to a contract tenders performance by attempting to perform their obligations under the contract. They are prevented from performing by the other party. Depending on the type of contract, the trending party, in this example, the IT consultant, may be considered to have discharged uh, their obligations uh, under the agreement and the contract terminations. Uh, sorry, by other party depending discharge under the agreement and contract terminates. So, if the consultant is tendered performance is refused by the other party, they may be sued for breach of contract. Further performance is not required, uh, but the debt arising under the contract of a product or services is not discharged. In debtors creditors relationship, if a debtors tenders payment for the debts and the creditors refuses it, then they still need to pay. So if the debtor is paid after tendering performance, the money is usually paid into court as part of the defense of under. So basically by seeking to fulfill their contractual commitments, IT consultant tender performance under the contract depending on the kind of contract. So it may be believed that the offering party, in the case the IT consultant has fulfilled their responsibilities under the agreement and the contract ends. If a debtors offer payment for a debt and the creditors reject it, then they are still obligated to make the payment under debtors creditors agreement. So if the debtors receive payments, the fulfillment of the tender, the funds are often deposited into court as part of the tender defense. So termination of agreement, it is always open to parties to agree to variation to their contractual agreement arrangements. That includes termination it by agreement. Uh, Both parties are able to consent to termination of a contract when they do. The mutual obligations to perform contractual obligations come to an end. Variation to terminate. Uh, Hello, who's there? Hello, hi Jacqueline. Hello, can you hear me? Hello, can you hear me, Jacqueline? Okay. Anyway, that includes terminating it by agreement. Both parties are able to consent to termination of a contract. When they do, the mutual obligations to perform contractual obligations come uh, to an end. So variation to terminate. So this termination by agreement is actually a variation of the contract. As such, it must be supported by fresh consideration to be legally binding. So, where both parties have performance obligations, executory consideration outstanding under a contract, and agreement to discharge one another from further performance will usually be fresh consideration that enough to satisfy the requirement for consideration, making determination by agreement legally binding. So here, basically, it says it is always possible for parties to come to an agreement on changes to their contractual terms, including the termination of agreement of the agreement. Agreement may be terminated with the approval of both parties. Agreement to release one another from further performance. Uh, Often fresh compensations if both parties have unfulfilled performance duties. For example, executor consideration under a contract that is sufficient to meet the demand for consideration and make the termination by agreement enforceable. Hello, can you hear me, Jacqueline? Hello, can you hear me, Jacqueline? Hello, anybody can hear me? So, yeah, right. We'll carry on legally binding variation for termination. So for the agreement to legally binding, there must be either fresh consideration from both parties, deed releasing the other party from their obligations. There is no requirement for consideration uh, in a deed. So a separate agreement supported by fresh consideration to amount to accord and satisfaction or promissory estoppel applies to the facts. Broadly speaking, an estoppel is made out when a promise is made to uh, end the contract by one party to another. The promise intended to be binding uh, that acted upon by the other party and the other acts and on the promise and changes their position as a result. So the contract does not need to say that the parties intend to change the agreement in the contract itself. So even where a variation clause says that no variation or changes may be made to the contract, changes can be made to it by varying its term. So if there is a contractual procedure in a variation clause to change it, though that procedure should be followed. So the intention of the parties to modify the agreement need not to be stated explicitly in the contract. So, contract may be changed by changing its term, even if a provision prohibiting modifications or revisions to the indicate otherwise. However, if a variation clause has a specific method for changing it, that procedure must be followed. Uh, Conditions subsequent terms of contract can be built into a contract to terminate it. These are known as conditions subsequent. A condition subsequent stipulates a stop of affairs which cause existing contractual obligations to come to an end. So the state of affair, whether an event takes place or does not take place, does not have to be out of control of the parties. So contract may basically here he says that include provision of terminations. There are referred to as the following conditions. Following conditions specifies a situation that terminate any ongoing contractual obligations, current situation, whether an event occur or not. So does not always have to be beyond the party's control. So next termination for breach of contract. Termination for breach of contract requires a repudiatory breach of contract. Okay, here's the TLDR conduct is repudiatory. It is deprive the innocent party of substantially the whole of the benefit intended to be received for performance of the obligation under a contract. So this known as the substantially the whole benefit test. Repudiatory breach is often expressed as a breach goes to the root of the contract. So repudiatory violation of contract is necessary for termination for breach of contract. So the short version is that behavior is repudiated if it is deprive the innocent party of essentially the whole of the benefit which was expected to obtained in exchange for fulfilling contractual commitments. So breach is the breach serious enough? So to terminate the contract, it says that it is a serious breach or what. So if it needs to be a serious breach, not a breach of warranty, that is a breach of a condition or breach of uh, in nominate, aka intermediate term, which deprive the innocent party of substantially the whole benefit of the contract, are repudiatory breaches of contract and therefore sufficiently serious or terminate a contract. Hello, anybody can hear me? Okay. Uh, the next is contract may set out a different standard of breach, such as a material breach, fundamental breach, substantial breach, or serious breach. So, uh, basically it says that fair reading of these alternative expression in the context of the contract will determine whether they really indicate repudiatory breach. If the parties to business contract agree to end the agreement is according with the certain provision, they may do so. So, and just because there are no express right stated to permit a party to terminate in a contract does not necessarily mean that it can't be terminated. So, next one is anticipatory breach. So, when one party expresses an intention to not perform their obligations under the contract or perform them in a way in which is inconsistent with the original contractual terms, it is an anticipatory breach. It entitles the other party or terminate. So, anticipated breach may be caused by either explicit or implicit behavior, expressive language. Writing is not necessary. The innocent party may do not the following when defaulting party commits an anticipatory breach. So basically wait and let the party in breach to properly carry out in contractual responsibilities. The party in violation forfeits the rights to terminate if they do this. So has the option of confirming the contract by fulfilling their responsibilities under it. So when the innocent party needs to other party's assistance to carry out the agreement, or if they have no genuine stake in its fulfillment, neither option accepting the repudiation or terminating the contract is, if possible. So the option of accepting the repudiation or terminating the contract is not available where the innocent party requires the cooperation of the other party to perform the contract, or if they have no real interest in performance of the contract. So when there is a repudiatory breach, okay. So when there is a breach of contract, it does not automatically discharge the contract. Once you have a right to terminate, it must be exercised to terminate the contract. The exceptions to this rule are rare and limited. So until the right has been exercised, the contract continue in force. The right to terminate is exercised by telling the party in breach that the contract is terminated. It helps to explain all the reasons why to when you do. So when a contract is terminated, the performance obligations under the contract are discharged at the date of termination. So, however, performance of secondary obligations are not discharged and continue in such force, such as maintaining the confidential information of the other party or obligation to party damages for any losses caused to the innocent party. So, violation of a contract does not, inevitably result in its termination. You have a right to terminate. If you have a right to terminate, you must use to in order to end the agreement. So next one is wrongful termination. So attempting to terminate a contract in absence of a repudiatory breach is a repudiatory breach in its own right, even if you are mistaken and think that a repudiatory breach has been committed. So when that happens, it means that the other party to treat the contract as discharge and claim damages. This happens when an innocent party think they have a serious repudiatory breach and they don't. For example, here is talking about one of the case law, which is navigation versus Molina Alpha, federal commerce and navigation versus Alpha 1979. The owner of a ship wrongly believed it was entitled to repudiate the contract. It was not. So the repudiation was wrongful, and therefore the other, new now innocent for legal purpose party could treat the contract as discharge, that because the owner was in repudiatory breach itself. So even if you believe that a repudiatory breach has been committed, trying to terminate a contract in the absence of a repudiatory breach constitutes a repudiatory breach in its own right. So if such occur, the opposite party will regard the contract as discharge and will seek uh, compensation or damages. So remedies of breach of contract or compensations or remedies means that basically says that damages are the main remedy for contract violation. It may be possible to get injunctions to prevent further violation of the agreement. So if the agreement has not already been cancelled. So the primary remedy for breach of contract is damages. Injunctions may be available to restrain further breaches of contract, which assume that the contract has not been terminated, as I said, if contract has not been cancelled. So termination, next one is termination by frustration. So by common law, discharge by frustration occurs where it is impossible to perform the obligations under a contract due to a change in circumstances of a performance of a contract after it has been signed. So The changes of circumstances must change the nature of the outstanding contractual obligations. The modern test for frustration is outlined in the case of National Carriers versus Panel Pina 1981. Frustrations occur when here is a case law. Is discussing super Venice as event without default either party, and for which the contract makes no sufficient provision, which is significantly changes the nature, not merely the expense or of the outstanding contractual rights obligations from what the parties could reasonably have contemplated at the time of its execution. So that it would be unjust to hold them to the literal sense of its stipulation in the new circumstances. So discharge by frustration rise when it is impossible to carry out the terms of a contract, because those terms have changed after the contract has been signed. So the nature of the unfulfilled contractual duties must alter as a result of the change in circumstances. Example situation of fracture here is talking about one of the case law, Taylor versus Caldwell 1863. A contract to hire a music hall was frustrated when the hall was destroyed by fire. Uh, another is a party whose individual rather than a separate legal entity to the contract dies, or uh, it is seriously incapacitated. The contract has been become illegal performed due uh, to a change in the law, uh, or say an outbreak of war. So the commercial purpose of the contract has failed, such as the failure of an event which the contract was based upon. So here he is talking about the Taylor versus Music Hall rental agreement was nullified when the venue was completely destroyed by fire. So commercial purpose of the contract has failed. So such as the non-occurrence of an event on which the contract was predicated, a party to the contract dies or becomes seriously disabled, or contract can be terminated. So frustration will not apply to discharge a contract. So uh, anybody can tell me frustration will not apply to discharge a contract or not? What? Any idea? Okay, right. Simply because inconvenience has been caused, or rather, has been an increase in expense or loss of profit. Uh, in Davis Contractors Limited versus Fairham UDC 1956, it was agreed that a council estate would be built at a fixed price. So, due to bad weather, strikes, and shortages, delays uh, ensued. This estate was built at a loss. The contract had not been frustrated, it was just more expensive to perform the contract. The contract contains an express provision such as a force majeure clause. Uh, hello? Yeah.
Hello?
So, hi, Jacqueline.
Yeah,
Have you got
hello.
any issue? Uh,
Yeah, I've got an issue with the internet
oh,
connection.
okay, all right, okay. I was thinking, so there you can see
Yeah,
that there's the issue.
if you could kindly send me the link to the live lessons later, I really
Yeah,
appreciate
yeah,
it.
that's fine. Today is the last lesson, so you mean to say that for next week?
Yeah, yeah. No, I
Yeah,
mean
yeah,
for today's lessons. Today's lessons.
yeah, yeah. So today is okay.
Oh.
You're okay with this lesson
Yeah, I'm okay, but I'm finding it a hard time connecting because
because of internet.
yeah,
Okay,
because
okay. Anyway, we are just that
it's quite unstable.
middle of this lesson, so we'll discuss after that. Okay. So I'm here. That frustration
Yeah,
will
yeah,
not
sure.
apply to discharge and contract. So frustration is self-induced, and one of the parties which had a choice regarding performance. the event was reasonably foreseeable by either party as at the date of the agreement. So, terms of contract. So, terms of contract basically, if I say in my own words, agreement include a variety of terms that provide cancellation rights for business to business contract. So there are a wide area, of contract clauses that can appear in agreement to set up business to business contract cancellation right. So ability to rely on cancellation right lawfully depends on express terms of the specific contract and terms of contract which would be implied by law. So, even if a business to business contract does not contain an express right to terminate, such as a termination or break clause, implied right may exist to bring about the contractual power of termination of the contract. So, it might be that the term of the contract contains an automatic renewal clause. And if a contracting party tries to terminate a contract and does not to have the right to itself is repudiatory breach of contract. So, have you got any idea about repudiatory breach? Hello, can you hear me, Jacqueline?
Hello. Yeah, I can hear you. Hello.
Have you got any idea about repudiatory breach?
No.
Okay, basically in contract, you know that repudiatory breach is a contract or situation where someone, or one party refuse to do something that they should do by law or legally, that required to do. Okay,
Okay.
so next is page 20, is talking about COVID, coronavirus and termination. For example, it is widely accepted China uh, is the workshop of the world. It is known for manufacturing goods of all standards. There's a real risk that the temporary closure of factories arising from COVID-19, coronavirus 19, and affects delivery on short supply chain and businesses that rely on just-in-time procurement. Okay,
Okay.
so it's a very simple that it says that affected because of COVID-19, 2019. So next one is is talking about examine
Yeah.
the difference between breach of conditions, warranties, and innominate terms. So uh, contractual terms can either be conditions, warranties, or innominate terms. Traditionally, contractual terms were classified as either conditions or warranties, and then uh, categories. A category of innominate term was created in Hong Kong. Fair shipping. It is important for parties to correctly identify which terms are to be conditions and which are to be warranties. So Uh, basically, contractual terms might be conditions, guarantees, or identified terms. So, contractual ones were formally, categorized as either conditions or warranty. So, he is giving you example of fair shopping invested the concept of in nominate words. When a contract has been broken, it is crucial to identify basically kind of provision was violated in order to establish the appropriate remedy. So where there has been a breach of contract, it is important to define which type of term has been breached in order to establish the remedy or compensation available. Okay. uh, are you okay, Jacqueline? Is it working now? Right. So condition is a major term of the contract which goes to the root of the contract. If a condition is breached, the innocent party is entitled to repudiate the contract and claim damage. So here is an example of Possard versus Spires, 1876. Madame Possard entered a contract to perform as an opera singer for 3 months. She becomes ill 5 days before the opening night and was not able to perform the first 4 nights. So Spires then replaced her with another opera singer. So Badam was in breach of condition and Spires were entitled to end the contract. She missed the opening night, which was the most important performance, as well as all the critic, critics and publicity would be based on this night. So next one is warranties. Warranties are minor terms. Okay, warranties are minor terms of minor terms of contract which are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damage but can not end the contract. So if party breach any warranty, they can't terminate the contract, but they can claim the damage or compensation. Like Bettini agreed by versus Gay by Guy by contract to perform as an opera singer for a 3 months period. He became ill and missed 6 days of rehearsals. The employers sacked him and replaced him with the another opera singer. Bettini was breach of warranty and therefore the employer was not entitled to end the contract. Missing the rehearsal did not go to the root of the contract. Sorry. So here again, he's talking about Hong Kong fair shipping, as discussed previously, served as the foundation for the innominate word strategy. So the courts may rule that a provision was just a minor term, even though the parties themselves had claused it as a condition, and a violation of that term did not give rise to the right to repudiate the agreement. So as a result, uh, you know, in fair shipping and Kawasaki Kessen is a case law. Uh, as a result, the ship was out of commission for 5 weeks and then other 15. The defendant saw this as a condition violation and terminated the agreement. Held the court should consider the consequences of the breach and they determine whether the innocent party has been significantly deprived of all the breaches benefits of the contract rather than attempting to qualify the term itself as a condition or guarantee. So the defendant 20 weeks out of a 2 year contract terms did not materially deprive them of all benefits. So that's why they were not allowed to repudiate the agreement in simple words. So compare the case. Here he's talking about that Sushler versus Wickman tools. Sushler were manufacturer of a certain tools, and Wickman were a sale company granted the sole right to sell certain tools manufactured by Sushler. In terms of the contract between the parties was described in the contract as being a condition and provided that Wickman would send a salesperson to each named company once a week to solicit sales. This imposed an obligation to make 1,400 visits in total. Wickman failed to make some of the visits and Sushler terminated the contract of breach of condition. So, hell, despite the fact the contract had expressly stated the term was a conditions, the House of Lords held that it was only a warranty. Right? So, uh, uh, Lombard North Central versus Butterworth, 1987. The defendant leased uh, a computer from the claimant. The claimant was to pay £584 by 20 installments by 3 months. By terms of the lease agreement, provided that punctual payment was required, and a breach of this term would entitle the lessor to leaser to terminate the agreement. The defendant got into arrears with the installment, and the claimant took possessions of the computer and sold it on for £175. The claimant sued the defendant claiming arrears and all future payments amounting to £6,869 in total. So held. The term releasing to prompt payment was a condition. That condition was prompt payment, quick payment. The parties by either agreement had demonstrated that prompt payment was an essential term, and the consequence of breach was clearly set out. Nichols LJ stated that even one late payment would entitle to leisure to terminate irrespective of the effect of the breach. So examine the doctrine of frustration. So in English law, a contract may be discharged on the ground of frustration when something occurs after the formation of the contract which renders it physically or commercially impossible to fulfill the contract or transform the obligations to perform into a radically different obligations from that undertaken at the moment of the entry into the contract. So historically, the concept of frustration has been invoked to mitigate the wondrous doctrine of absolute contracts, where performance of a contract is prevented by supervening events for which neither party to the contract is responsible, and loss allocation is required. So basically, in the past, the idea of frustration has been to lessen the burdensome notions of absolute contracts, which requires loss allocation when supervening circumstances impede the fulfillment of a contract for which neither party is accountable. So uh, the test of frustration. So the in juristic basis of the doctrine has evolved over a number of years. So doctrine's basically legal foundation has changed throughout the years. The concept of a fair solution basis of the contract, failure of consideration, and implied term have all been rejected by English courts throughout time in favor of the test of dramatic changes in the duty, which is presently seen by major commentators as the preferable method. So the principle of frustration is not, activated by difficulty, annoyance, or material loss per se. The importance of the responsibility must also alter to the point that if fulfilled, the item done would not be what was originally agreed upon. So here, the test was first formulated by the House of Lords in Davis Contractors versus Fairham, case law. So next one is furthermore, it is not simply a question whether there has been a radical changing in the circumstances, but whether there has been a radical changes in the obligation or the actual effect of the promises of the parties in the right of the new circumstances, which the court will have to establish that the performance was fundamentally different in a commercial sense. So it is necessary for the courts to demonstrate that the performance was fundamentally different in a commercial sense in order to determine if there has been a significant changes in the obligation or the real impact of the parties' commitments in light of the new circumstances. The application of the law of frustration is not always precluded by the fact that the parties but at the time of contracting truly foresee the possibility of the occurrence of new circumstances in issue. So however, the fact that parties at the time of contracting actually for you know saw the possibility of the event and new circumstances in question does not necessarily prevent the application of the doctrine of frustration. So there are 5 points key frustration features of the doctrine of frustrations. He is talking about Laureate then versus which smaller BV super servant to uh, out the following five propositions which he regarded as the essence of the doctrine. So the five positions: frustration, mitigate the rigor of the common laws, insistence on literal performance of absolute promise doctrine, operate to kill the contract and discharge parties from further liability under it. Frustration brings a contract to an end forthwith, without more, and automatically. It should not be due to the act or election of the party seeking to rely on it, so that there must be some outside event or uh, extraneous change in the situations. A frustration event must take place without a party fault, for example, cannot be self-induced. So basically, fourth point that believed to be a sense of the doctrine where as that follows: frustration lessen the strictness of the common laws, requirement of literal performance of absolute promise, and the doctrine functions to kill the contract and release parties from future liability under it. So frustration brings a contract to an end, so forthwith, without more, and automatically. So legal effect of frustration. English law views is that frustration operate not only automatically without the choice or election or either party, but also totally. What this mean in that the obligations of both parties are wholly discharged in so far as performance of them had not fallen due when the contract was frustrated. So basically, frustrations work not automatically but also completely. This implies that, in as much as fulfillment of those duties had not become due when the contract was frustrated. So both parties are fully released from those responsibilities. So English authorities have rejected this strategy basically, uh, because it would result in uncertainty with regard to the contents of the parties, so contracts, and put them in the unfavorable position of having to have their contracts drafted by the court. So here he's talking about law reforms 1943. The legal consequences of frustration relating to recovery of payment made are broadly covered by the Law Reform Frustrated Contract Act 1943. Basically, the Law Reform Act of 1943 generally addresses the uh, uh, legal reforms of frustrated contract law with regard of the to the recovery of monies given. So here, a practical illustration of frustrations. So basically, the expression frustration of contract refers to the general doctrine of discharge by supervening events, irrespective of the type of event which brings about discharge. Over time, the English authorities have addressed a number of events that potentially give rise to frustration. The following is a non-exhaustive list of such events. So, like destruction or unavailability of the subject matters, death, illness, incapacity of a person, dissolution or supervening incapacity of corporation, frustration of purpose, and or changes in law, outbreak of war, delay sufficiently long to frustrate the party's commercial adventure, method of performance impossible. So basically, English government has addressed variety of situation that might lead to uh, annoyance over time. So non-exhaustive list of similar, as we discussed here, it as your slide says as well, destruction or non-availability of subject matters, death, illness, incapacity, person, dissolution, so defeat of purpose, outbreak, war. So uh, these kind of stuffs, method of performance impossible or fundamentally different. So That's it. Review of the convention on contracts for the international references here. So that's it for today. You know, Basically we discuss what is contract law. Understanding how a contract can be discharged, what is contract and how contract can be discharged, type of contracts, breach of contracts, different ways in which a contract can come to an end, like we discussed in detail, like performance, by agreement, breach of contract, by law of frustration. So that's it for today, guys, and hopefully I'll see you next weekend, next Saturday, I believe so. It is about assignment brief. So have a lovely evening, and my name is Yasser Gulfraz. If you need any question, any help, or
Sorry,
if you
can
have
I?
it, I'll just come to
Sorry.
you. Just give me a second. So
Okay.
if you have any question, please drop me an email at tutor-management@ukversity.co.uk. Uh, thank you very much,
Okay.
and bye for
No
today.
problem. Thank you.
Yeah,
Bye.
yes, Jacqueline.
Hello.
Yeah, yeah.
Hello.